the end of the day, we come back to the common theme of justice. The negative and affirmative team don't disagree on the concept that we need to uphold justice in the United States, and we need to be just as the US. However, what we disagree on is whether this change will create advantages over the current system. The current system already allows for federal courts to be used. Why is there a change necessary? Well, not only is there not a change necessary, but that change would actually cause significant disadvantages to the current system. And that is exactly what I'm going to be going over in today's speech. I'm going to be looking over 3 main disadvantages that the negative team would like to point out and really impact. Then also go over 2 significant points and really sum up the stance of the negative team in those last few points. With that being said, let's jump in right to my disadvantages. And I'm going to be going over 3 of them. The first of which is that it harms national security. It harms national security. And I have 2 main subpoints it harms national security. We can see this from a piece of evidence from Jennifer K. Elza, who is a legislative attorney on the Congressional Research Service, who said, quote, "The Military Commissions Act of 2009 provides that the Military Commissions judge may close proportions of the trial only to protect information from disclosure where such disclosure could reasonably be expected to cause damage to national security, such as information about intelligence or law enforcement sources, methods, or activities, or to ensure the physical safety of individuals. The information to be protected from disclosure does not necessarily have to be classified." So we can see that in the military commission system, it provides the judge with the ability to close a trial and to actually hold back some information if it is actually risking our national security. And I'll be jumping into a little bit more of the response that I know the affirmative team will come up and say to me, and showing why their response is not actually valid. Now, to go along with that, it alluded to this in the piece of evidence, but I like to say in the federal court, this disclosure is not necessarily upheld. Now, they'll come up here and state that basically the classified information standards are very similar. However, due to this piece of evidence from Louis Gilbert in 2010, quote, "In district courts, a classified information is not as protected as in military tribunals. Civilian terrorist trials after the 1998 bombings of U.S. embassies in Africa required disclosure that we obtain intelligence through defendants' cell phone usage. Terrorists stopped using cell phones, and we lost that we may have saved lives. When courts ruled required disclosure of indicative co-conspirators, bin Laden had the names within 2 weeks. Trials before a military commission afford defendants constitutional protections, but weigh them more effectively against the needs of classified information." So basically what happened in this trial, or in this example, we see an example of when actually in a federal court, cell phone usage was used as an example. This got out to the press and the public, therefore terrorists stopped using cell phones, therefore we failed to provide any more intelligence on the issue because of that threat. So terrorists actually changed their ideas in order to conform or get past that issue. This is not protected in the federal court. This classified information is not as protected. It is still protected, but it is not as protected. And due to the evidence stated in 2010, we see that it still applies under the 2009 change of the military commissions. Now, to go along with that, the advantage produced by, another disadvantage provided by the federal courts regarding the idea of national security is that the federal courts allow for insignificant evidence that is important to national security to be leaked. We see this in another piece of evidence by Michael Muskie, who said, quote, "The testimony in a public trial, particularly under the probing of appropriately diligent defense counsel, can elicit evidence about means and methods of evidence collection that have nothing to do with the underlying issues in the case." So they are actually leaking not classified information, but simply confidential methods and evidence that simply was leaked in order for terrorists to skirt around the issue of these courts, therefore harming our national security. And we can see that this is a major disadvantage in the system. When we simply eliminate the military commissions, we will only be trying these terrorists in federal courts, therefore always allowing for that to be a possibility. That cannot happen. But moving on to my second disadvantage, and that is the disadvantages of injustice. And this is really an interesting point or disadvantage to bring up due to the fact that the affirmative team's goal itself is the upholding of justice, that they aim to uphold justice. Federal courts do not always uphold justice. Military commissions have been seen to uphold justice. In any instant, courts will make mistakes. But in the instance, in this specific example I want to bring up, the federal court made a major error in this part. And we can see this from Danny Gonzalez, who said in 2013, quote, "In 2009, under the direction of Attorney General Eric Holder, the trial of suspected Ahmad Ghaili was moved from Guantanamo Bay to federal court in New York. Gandhi helped plan and carry out 1998 U.S. Embassy bombings in Kenya and Tanzania. Due to the legal rights and protections given to Gandhi by moving that trial, critical evidence was made inadmissible, and as a result, prosecutors were only successful in convicting Gandhi on a partial conspiracy charge. He was acquitted on 200 or more murder charges. Due to the fact that we were not allowed to use all the evidence regarding the case and all the different examples or pieces of evidence, he was acquitted of 200 or more murder charges, therefore not sufficiently attaining justice, failing the actual goal of the affirmative team. The current system shows that both military commissions and federal courts can be used, and that it is up to whether or not whichever situation or whichever trial is going on fits the needs best can be chosen. Military commissions might be better in some cases, federal courts might be better in some cases. That is the stance of the negative team. Moving on to my third disadvantage, and that is that federal courts are risked. Federal courts are risked, and I have a few pieces of evidence to show this. First of all, quote, Michael Muncy said, "Moreover, there is every reason to believe that the places of both trials and confinement for such defendants would become attractive targets for others intended on creating mayhem. Whether it be terrorists intent on in inflicting casualties on the local population, or lawyers intent on filling waves of lawsuits over issues as diverse as whether those captured in combat must be charged with crimes or released. The conditions in confinement for all prisoners, whether convicted or not." So to sum up the piece of evidence, it's simply saying that it opens the possibility, if we put all these terrorists on trial in federal courts, it opens the possibility and really enhances the chance that people will take advantage of that and use it for lawsuit issues to kill the population or harm the population, or find ways in which they can free these people. So we can see that in that last disadvantage. Now moving on to the last significance point, and I have two significance, and that is there's no change. There's no change. Federal courts are used in the current system, and most in fact of these terrorists are already done in the federal. Most of these trials are done in the federal courts. Therefore, it's insignificant. Which moves me to my second significance point, and that is military commissions have no reason not to be in place. That there's no reason to remove military commissions because they are a viable option in the current system, and something that we as the negative team think should be in place, both the federal and military commissions. Thank you.